Okay, and we're back. The next topic is going to be venue, transfer, and forum non-convenience. Hello? I'm not just speaking, I'm the camera person as well. All right, again, the caveat on this video is intended just for those taking the MBE. I'm trying to hit up some of what I think might be some of the more major topics. I can't hit everything, and I can't hit everything to an excruciating level of detail. Accordingly, keep in mind that I can't cover everything, and if you're a JD student, this is a much more cursory review than you would want to have, say, in a JD class. Because in the JD class, we go into a much more level of detail in the class and on the exam. So, venue. If subject matter jurisdiction is about the court's power to hear a particular type of dispute, and personal jurisdiction is about the court's power over the defendant or over property, well then venue is, once we're within a court system, what is the proper place for trial itself, or proper place or places for trial? All right, so let's talk about venue first. Well, one thing to note about venue is a caution, and this is a real trap. And I've tested on this in the past as well. Another bonus for you students that actually bother to watch this video, JD students. Removal. The proper venue for a removed case is measured by the removal statute itself. There's one and only one initial proper venue for a removed case, and that's the district that corresponds to the state court. So if you remove from Dade County State Court here in Florida to federal court, well, the proper venue is going to be the Federal District Court for the Southern District of Florida. And that's it, all right, for removed cases. That's how you measure venue, 1441A. But now let's talk about cases originally filed in federal court. There's a whole bunch of venue statutes. There's actually a number of them. I'm only going to talk about the general venue statute, in particular, Section 1391, the general venue statute, which provides three bases for venue. So that should tell us from the beginning that proper venue can be one place or it could be multiple places. You could have more than one proper venue. You have 1391 B1, B2, and B3. All right, B1 looks to where people reside. B2 looks to where stuff happened or didn't happen, or where property is located. And then B3 is a fallback. All right, well, let's go through them one by one. All right, B1 says venue is proper in any judicial district. That's our first clue. Venue is not measured by states. It's measured by judicial districts, and that goes through any of these provisions. So, for example, here's Florida, right? It's an awful picture of Florida. All right, but here we have the Southern District, the Middle District, and the Northern District. Well, if we were talking about personal jurisdiction in Florida, we'd ask whether there's PJ with the whole state, right? But when we talk about venue, we're talking about whether there's venue with a particular district. So always be clear about the distinction between states and districts. Some states, like Alaska or Hawaii, only have one district, all right? But other states have 2 districts, 3 districts, even 4, right? Texas, I believe, has 4. California, I believe, has 4. All right. So B1 resides. Well, under B1, venue is proper in any district in which any defendant resides, as long as all defendants reside in the same state. Well, how about a hypo or two? Suppose you have a case, a citizen of Florida, or let's say someone who is from Anchorage, Alaska, suing somebody who resides in Miami and somebody who resides in Tallahassee. Okay? Now, under B1, venue is proper in a district where any defendant resides, so long as all reside in the same state. Do both defendants reside in the same state? All right. Miami is within which district? Southern. Tallahassee? Northern. So venue would be proper in the Southern or the Northern district. What if we have a third defendant who is from Pittsburgh, Pennsylvania? Can we use B1? No, because all defendants do not reside in the same state. For B1 to be used, you can only use it if they all reside in the same state. All right. B2 asks where things happen. Venue is appropriate in any district where substantial events or omissions giving rise to the claim occurred, or where it says something like where the property is located or substantial property. Look at the language itself. You know, it's something essentially like that, right? So where stuff happened or failed to happen or properties located, okay? So say, for example, we have, let's do it like this. All right, here we go. Miami, Tallahassee, and Pittsburgh, and it's a 4-car accident in Orlando. All right. Where is venue appropriate? Only in Orlando's in which district? Middle District of Florida. So in this fact pattern, only the Middle District is appropriate. Now, what if we get rid of the Pittsburgh defendant? Now it's someone from Anchorage sues people from Miami and Tallahassee for an accident that happened in Orlando. All 3 districts. Why? Because under B1, we're going to have the Northern District of Florida and the Southern District of Florida because of B1, because all defendants reside in the same state. And so we can use Southern District and Northern District because they all reside in the same state. So venue is appropriate in any of those 2 districts, Southern and Northern Florida. All right. And then under B2, the accident happened in Orlando, so we have the Middle District of Florida. Okay? So look, you can have more than one district under the venue statute. Isn't that cool? All right. Now what about the fallback? Well, let's illustrate with a hypothetical. When you look at the language of the fallback, that's 1391b3, it only kicks in when there is no other district where venue may be found. Okay? No other district. All right? Here's an example. Citizen of, let's see, someone from Anchorage versus someone from Miami and someone from Pittsburgh, all right, for a bar fight in Tijuana, Mexico. Now I'm thinking everyone went down to Sammy Hagar's Cabo Wabo bar and where is it? Is it in Tijuana? No, it's in Cabo Wabo. Cabo Wabo's a place, isn't it? Where is it?
Cabo San Lucas.
It's Cabo San Lucas. Okay, where Sammy Hagar has his famous, bar and establishment. Okay, so these folks get into a bar fight. Well, wow! Can we have B1 venue? Nope, they don't reside in the same state. How about B2, where stuff happened? Nope, because stuff would have had to have happened within a judicial district. And Mexico is not a judicial district. It's outside of the United States. So now B3 fallback kicks in. So you can only use the fallback if you have a fail on B1 and B2. All right? B3 kicks in and tells you that there's going to be venue in any district where any defendant is subject to PJ. What does that mean? Well, that means we have venue here under B3 in the Southern District of Florida. And anybody know where Pittsburgh is in? Which district? Western District of Pennsylvania. That's right. Western District of Pennsylvania. Those are my old digs. Both of these are appropriate because this person's subject to PJ and PA. But remember, we're measuring by districts and not states, right? We treat districts like states. So this person here, down here is subject to PJ in Western District of Pennsylvania. This one's subject to PJ in the Southern District of Florida. And the law tells us venue is appropriate in any district, not state, any district where any defendant is subject to PJ. Okay? That means these 2 places. So venue would be okay in either of these 2 places, but you can see that there's a problem here because venue would be appropriate in either the Western District of PA or the Northern District, Southern District of Florida. Venue would be appropriate for both of them in either of those places. But what's going to happen if we sue in Miami Federal Court in the Southern District? Is there another problem that's going to come up? There's no PJ over the second defendant, right? So that's a real problem. But you know, that does happen. So keep in mind that even though there's no PJ over this person if you sue in the Southern District of Florida, there's no PJ over this person if you sue in the Western District of PA, nonetheless there would be venue over both of them, right? Isn't that interesting? All right, some more stuff on venue. How do you determine where somebody resides? Well, for purposes of venue, you reside in a district in which you are domiciled. So here's yet another example of where domicile becomes really important under the law. So our Miami defendant resides in the Southern District of Florida because that's the district in which they're domiciled. What about corporations? All right, a corporation, generally speaking, is also subject, or excuse me, a corporation also resides in any district where it's subject to personal jurisdiction. Now, there's some additional complications regarding states, corporations that are spread around the state, but I'm not going to get into them because they're quite complicated. I think they're unlikely to show up in the bar. So the basic rule, just think a corporation resides in any district where it's subject to personal jurisdiction. And beyond that, I'm just not going to get into it, and we can talk about it outside of the session, or you can contact me. What about foreign individuals? What about people residing outside the United States? Well, what the law tells us is if the only defendants are residing outside the United States, if they're domiciled outside the United States, then they can be sued in any district. So suppose it's someone from Miami versus someone who resides in Paris, okay? Well, under the definition in the venue statute, you can actually sue them in any district for purposes of venue, because somebody who resides outside the United States can be sued in any judicial district. But what if you have Miami versus Paris, Miami, or not Miami, let's make it Anchorage versus Miami, Paris, and Tallahassee, okay? Anchorage versus Miami, Paris, and Tallahassee. How would we analyze venue, right? Well, first of all, reside is only relevant under the first of the three bases, right? Reside has nothing to do with B2 and nothing to do with B3. It has everything to do with B1. So would we be able to exercise venue under B1 in this fact pattern? And the answer actually is the intuitive answer is no, but the actual answer is yes. The law tells us that a foreign individual can be sued, there's venue over them in any judicial district. However, what if you have additional defendants who reside in the United States, right? Then what it tells us, for purpose of venue, we ignore them. Now, can we exercise B1 venue? Yes. Northern District of Florida and Southern District of Florida. All right, so that's it for 1391. Let's spend just a few minutes talking about some other aspects of venue and transfer. First is transfer under 1404 and 1406. And here I want to very quickly put a little chart on the board. This will take just a second. So here we go. See my speed drawing skills. Here we're going to have 1404, 1406, and forum non-conveniens. All right? First, let's start over here. 28 U.S.C. 1404 is the venue transfer statute. That permits federal courts to transfer from one district to another district for convenience of the parties and the witnesses, the interest of justice. Okay? So, for example, suppose venue is proper in the Southern District of Florida, but it would also be appropriate in the Northern District of Florida, and that's actually a more convenient place, right? Well, under Section 1404, the federal district court can transfer from one federal district to another federal district. You can't transfer from a federal court to a state court, or from a state court to a federal court, okay? But if you're within the federal court system under 1404, you can transfer from one district to another for convenience, all right? 1406 is used when venue is improper. So you know all the stuff we talked about, 1391, how to measure proper venue? Well, suppose something is filed in a district and venue is improper, right? Well, what should the court do? Well, under 1406, whereas 1404, the question is keep or transfer, right? Stay in that district or transfer to another district. The question under 1406 is dismiss or transfer. All right, so if venue is invalid, then the court has two choices. Choice one is to dismiss the case. Choice two is to transfer to a place where venue would be valid. All right? Now, forum non-conveniens is when the venue is proper, but there's another court that's much more convenient for the parties, but transfer is not possible. That's the Piper Aircraft case, right? The case was filed in California court, removed to California federal court, transferred to Pennsylvania federal court, and then there was a motion to dismiss because of forum non-conveniens. And the argument was like, hey, we're in here in Pennsylvania federal court, and yeah, venue is now valid now, but guess what? It would be so much better if this case was litigated in Scotland. Well, can a federal court in Pennsylvania transfer to a Scottish court? What do you think? No, it's a different country, different sovereign, different court system. There's no such power. So what you do there is you either keep the case where it is or dismiss to permit refiling. All right, and all of this is shown by this chart up here. It's the same idea expressed in a different way. So what I'm giving you is the same information in two forms. If venue is invalid, okay, then that's going to arise under Section 1406, which permits transfer from the bad venue district to a district that has venue, okay? The issue might also come up under Rule 12b-3, because lack of proper venue is a basis to seek a motion to dismiss. And if the court decides to grant that motion, then what it's doing is it's granting the 12b-3 motion and using 1406 to dismiss, okay, because of a violation of Section 1391. Indeed, when I say venue is invalid, in real basic terms, that means 1391 is violated, okay? So 1406 kicks in the invalid. And the question is transfer or dismiss, right? Can't keep it because venue is invalid. What if venue is valid? In other words, 1391 was satisfied, right? Well, now the court has to decide, keep it or transfer it, right? Well, if it wants to transfer it, it uses 1404, all right? 1404, the question is keep it or transfer it. However, there is the option of dismissing if the place that's more convenient is in a different court system. That different court system could be in a different country, or it could just be in state court, right? We're in federal court, but the more convenient, we're in Pennsylvania state court, but the more convenient court is, let me turn that back. Say we're in Pennsylvania federal court, but the more convenient court is Alaska state court, right? We can't transfer from federal court in Pennsylvania to a state court in Alaska. That's just not possible. What you could do is dismiss under forum non-conveniens, then allow it to be refiled in the place that's more convenient. All right? All right, so that chart and this chart. Now just a very brief word on forum non-conveniens. Okay, forum nonconvenience is kind of a hard thing to obtain, because what the court is essentially saying is like, hey, yeah, venue is proper, everything's proper, we have subject matter jurisdiction, we have PJ, all that may be satisfied, but we're going to dismiss anyway, so it can be relitigated, right? So first, like, what if the statute of limitations would be expired in the forum country, right? Well, typically a court won't grant a dismissal under forum nonconvenience unless the defendant agrees to waive a statute of limitations defense, right? That makes sense, otherwise it would be unfair to the plaintiff. Courts give heavy deference to the plaintiff's choice of forum, so there's a heavy presumption against granting a forum nonconvenience dismissal. So the party requesting the dismissal under forum nonconvenience has to make a strong showing under the public and private interest factors of Piper, Aircraft, and Gilbert, which I'm not going to get into in any great detail. Those should be in your bar materials, okay? And I rather doubt you're going to be tested on them because they're going to be very factually intensive, thus not making for good multiple choice fact pattern. But basically the private factors are ones that are between the parties themselves. The public ones concern things like the court system and things like that, all right? What else worth noting on this? Last thing to note on forum nonconvenience is one important thing that Piper Aircraft told us was that forum nonconvenience dismissal could be granted even if that meant that the refiling would occur in a court system that had much more unfavorable law, right? So recall in Piper Aircraft, the case was filed in the United States because of California's favorable tort law, right? But the accident actually had happened in Scotland, and the plaintiffs were all Scottish citizens or decedents who were from Scotland. And the reason the case was filed in the United States is because you could get much better tort remedies in the United States. If the case was dismissed under forum nonconvenience and then refiled in Scotland, then the value of the case was much lower. The Supreme Court said, no, that's not a reason to deny a forum nonconvenience dismissal. Too bad for the plaintiffs. The Supreme Court said only if there was essentially no remedy in the other place, say the foreign country, would the change in the law be determinative or even relevant to the forum nonconvenience analysis. So for example, if subject matter jurisdiction would be lacking in the foreign country, then that would justify denying a forum nonconvenience motion. Anyway, so that's it on venue, and I'm going to pause the camera. Thank you.